A big welcome to Parry Field, especially to you, John Edwards, from the Privacy Commissioner. I've heard a lot about you, and it's great to have you here. And the culprit for bringing you here, Steve Lowe, is somewhat annoyed that he's had to be somewhere else. So he, nonetheless, was very keen on being here, and he's very involved in this sector, as the firm has been for many years. And but particularly pleased to be able to host you today and the conversation that we're going to have together. Welcome also to Hamish Flanagan, quite well known in this firm through famous relatives who have been part of this firm for many years. So welcome to Hamish, the Senior Investigator with the Office of the Privacy Commissioner. I do recall when the Privacy Act first came into force, and recall the impact or response from many of my commercial clients back in 91 or 93, was it? Yes, it was a raft of new legislation that swept through the country. Without commenting on that, I remember one client at the time making some comments about it, which I thought were abrupt. And rather ironically, the moment after Stephen asked me to step in and just do the welcome, I got an email from this client, not aware of this meeting or even aware that it's happening, but I thought it illustrated significant movement on his part in understanding and accepting the whole the necessity of privacy, but he didn't quite get as far as he might get. You'll understand why. Hi Grant, our New Zealand General Manager, has asked if you can review our updated privacy policy. So that's the high point. He's got that far. See her request below. If you need any further info, best to talk to her directly, as I'm a very private person. Signed, Anonymous. That was his way of saying I'm getting there, but not quite. I'm just going to hand over to Nathan shortly to deal with housekeeping matters and get matters underway, but I also should welcome the unseen audience on Zoom, that word that very few of us knew 2 years ago. But what a marvellous thing it is to be able to welcome everyone else that is joining us on Zoom to what I think will be a very helpful talk around an area, as I said, that we have considerable involvement in. Charities. I'm on 2 charitable boards myself. Privacy has become an increasing focus of the board around the issues that we face both here in New Zealand and as it relates to our staff overseas in those charities, which creates an interesting mix in terms of the impact of New Zealand law overseas applying to New Zealanders back at home. So John, welcome you here today. Aislinn, tell us where we need to go if we need to go somewhere.
Thank you. So like Grant said, thank you everyone for coming today. If you are on Zoom and you're having issues just hearing us, please let us know on the chat and we will help sort that out for you. As you can see, we've obviously got tea and coffee and drinks here, food here, so feel free to hang around afterwards and grab what you want. If you do need to go to the bathroom during this time, if you go to the right from this door and then to the left, you should be able to find it, or just look really lost and someone should point you in the right direction. If there is an earthquake or something goes wrong, we just need to go out the exit that you came in, just out those main doors downstairs. But if you do have any questions, just let me know and we should be able to help you. So we'll now invite John Edwards to come and speak to us. Thank you very much, John.
Thank you. Kia ora koutou katoa. Thank you for coming out on such a day. Thank you for putting on such beautiful Canterbury weather for us. And Grant, thank you and the firm for hosting us. We really appreciate it. It's Privacy Week, which is why we're here. Are we going to screen share or just
the one behind you.
Just okay. So people will just okay. Let's assume I can operate simple machinery. I'm here to update you about the Privacy Act 2020. We've had it for 6 months. I've spent many years going around the country saying, we're going to get law reform. There's a new Privacy Act coming. Get ready, get ready. And suddenly it came and we got it. And I don't want to assume you know too much about what was there before. How many people do we have on the Zoom? I can't quite read the participants. You're monitoring the chat, are you, Aislinn?
Yes, I am.
Okay, so I would welcome you to help yourself to a sausage roll and to fire in your questions by chat. I'm happy to be interrupted at any time. I'm here for you, so it's less important what I think you need to know than what you would like to know. Actually, maybe we'll start there. Quite often speakers do a big talk and then leave 5 minutes to say, are there any questions? Which means they've decided what they think you want to know. Let's turn it upside down. Are there any questions? What would you like me to cover while I'm here? I'm reasonably versatile. Why are you here?
Yeah, so, well, I've got all sorts of questions. So for those that don't know me, I'm Ken Prance. I'm General Counsel for St John, New Zealand. So we provide the ambulance service amongst other community programs. So like other providers these days, that means we have big computerized data amongst other things. So, we deal with about 500,000 individual call-outs a year, and that then generates all this other data behind it. So, and that's growing. Literally every minute we're getting more data, and we're having to control it and all of this, and we've got lots of people and they're all interacting with it. So the question I asked John just before this was, and I'll put our hand up and say, we have already notified you more than once, and I'm taking the view that we ought to and should be proactive about that. So I'm interested in a view about that. But the particular question I had was a situation where we felt we need to notify that also involves an employment investigation. So we've discovered the situation. We're thinking, well, look, there's a whole lot of issues here, but if you were just thinking about it as an employment lawyer would think about it, you would say, none of this is established yet. We have to run through our investigation. And your employment law requirements are we cannot reach a conclusion about this until we do.
You have to be fair, you have to follow natural justice and things. So the question's about the breach notification and the implications of that. And this is the value of asking the questions up front, because if I was going to talk to you about the new obligation to notify privacy breaches, I wouldn't have come to that question. Elizabeth, did you have something particular that you wanted to find out while you're here?
Same thing, breach notification.
Okay.
When to do it.
Excellent. When to notify breaches. Anything coming in on the chat, Aislinn?
So we have Tracy, who said these have implications for information posted online and databases.
Sure.
New organisations needing a form scratch policy, and if there is any resources available for considering on hosting info online.
Okay, thank you. That's a good starting point. And we have another.
Sorry, and this is probably more of a practical. I mean, we obviously, as legal teams, we can't be everywhere at all times. So if you were to say kind of, what are your top 3 things that we should be making sure our operational people understand on a day-to-day basis?
Excellent question.
To identify when they need to be getting advice.
I think it's great that the lawyers can't be everywhere all the time. That's a really good question, because, the Privacy Act has to be a law that is operated by and understandable by non-lawyers. And sometimes lawyers actually get in the way. And I mean, obviously, sometimes they add enormous value. I'm a lawyer myself, and so I don't want to trash talk the profession. But this is a law that has to be a very general application, and the basic concepts need to be understood. So communication is really important. Let me give you a little anecdote about that. We were plagued for many years by questions in our inquiries line about the operation of drones. They're going everywhere. Now, there's an exemption for things that you do in your personal capacity, right? So a nephew gets a drone for Christmas, he's flying it over the neighbour's place. It's actually not within our jurisdiction. But still, people naturally think privacy, drone photography, this is something we should do something about. So we partnered with police and civil aviation, and we thought we should insert ourselves into the supply chain somewhere. So we contacted retailers and said, if we give you a brochure, will you put it in every drone package that you sell? And they said, yes, we will. Then we had to condense a message about the Privacy Act, which is a couple of 100 pages long, the civil aviation rules, which are very complex, and get that into one readily understood brochure that could go into retail outlets and be read by a 14-year-old boy who gets a drone for Christmas. So what do? The top message and the bullet point was, don't be creepy. So we didn't worry about definitions of personal information or exemptions for domestic affairs. We just, top line it. And I think that's the challenge for lawyers, is reducing the elements of the Privacy Act down to their most operational. And that's a good introduction, I think. I'm going to try and tempt fate and show you the television commercial that we issued to promote the new Privacy Act in 2020. Has anybody seen it? A couple of nods. We'll see if we can run it. Oh, no, we won't. Have you?
It is ready to go.
It's ready to go? Oh, so we've got to click through.
Set it up.
Thank you. Oh. Sorry about this.
Personal information is precious. You have to treat it with care. If you're someone who uses personal information, you must protect it and respect it. Make sure it's hidden away from others, but easy for you to find. The Privacy Act has changed. You'll have to report serious breaches. Know what's new at privacy.org.nz.
Thank you. I'll just pause that. I'm just going to take it back to the start.
Technology has changed.
How many actors were in there? Three. Yeah. 3 little vignettes, 3 actors. Each actor has 2 parts. In the first scene, we see a young woman hand over her driver's license to a mechanic. The mechanic, in the next scene, is signing into a contact tracing register at a rugby club while somebody is sweeping up. The guy who's sweeping up takes the contact tracing register and carefully locks it away in a cash box. In the next scene, he's picking up his medical records from a medical centre, from the young woman who's now a nurse, from the first scene. And what we were trying to convey with this, if we could go back to the slide deck, thanks. What we were trying to convey with this is that we all move through the world in at least 2 different capacities. We are individuals who have entrusted personal information to St. John's, to the church, to Presbyterian support, to Parry Field, whatever it is. And we are individuals who are part of an agency who has duties and responsibilities as the custodians of other people's personal information. So coming to your point, what's the message? Well, there's kind of a golden rule. At very least, we should be telling people privacy is precious. Treat the information which we hold as you would like your own information to be treated. Now, maybe that's not maybe a universally applicable rule when you look at the way some people overshare online and things, but it's a reasonable start. Let's just, before we launch into some of the technical details and the legal stuff, remind ourselves what this law is. The Privacy Act applies to agencies. There's 2 or 3 concepts I just want to drill in. I know you're probably all familiar with them, but there might be 1 or 2 who are not, so let's not embarrass them by calling them out. Let's just go back to first principles. Privacy Act applies to agencies. An agency is the entity with responsibilities. And it's defined really broadly. It says an agency is a person or body of persons, whether corporate or unincorporate, and it's whether they're in the public sector, the private sector, or the not-for-profit sector. Okay? So it is the Catholic Church. It is St. John's. It is the Hagley Park Aerial Golf Club, if there is such a thing. It is the Tramping Club, the music teacher, the physiotherapist, the law firm, the pharmacy. You get the picture, the government department. It's across the whole economy. It's such a broad term. It's defined by reference to exclusions. It says an agency is everybody, but it's not the courts in relation to their judicial functions. It's not the Governor-General and it's not members of Parliament because they're dealt with sort of separately. It's not the news media in relation to their news gathering activities. So that's who it's covered. Almost everyone. Throw a stone, you hit someone who's subject to the Privacy Act. In respect of personal information. And that's a term which is defined as information about an identifiable individual. And there's no qualitative element in there. It doesn't say private information. It doesn't say sensitive information. If it's information about an identifiable individual, meaning someone who can be identified from the information, then it's personal information, so it's subject to the Privacy Act. I'll drill a second, just for a moment, into that idea of what's identifiable. Because that's not, there's little hooks in there as well, right? Because you might have a database and you'll say, okay, I'm going to strip out the names and the addresses, and now it's not identifiable. Sometimes you can identify someone through really innocuous information. I launched an inquiry last year to find out why emergency services, including St. John's, were receiving daily spreadsheets of people with COVID-19. And you'll know why I launched that inquiry. But in the publicity around that, somebody wrote to me and explained her experience of having been publicly identified. And it was horrible. She was vilified, her family was under a lot of pressure and indignities, and they were harassed online, and it was a really stressful experience while they were really sick. And there were teenagers who were ostracized from their school and social groups and things. So awful. But that aside, the interesting part about this is how she was identified. So what happened was, in this region, the mayor was talking to the DHB, and the DHB said, we've got one case in X town, right? So a person in a town of a couple of thousand people has got COVID. Can you identify anyone from that? Of course you can't. Until next week, Ashley, at one of his afternoon 1 p.m. briefings, said, well, we've identified that the cluster is associated with the Hereford Breeders' Conference. Guess how many Hereford breeders live in X town? One. So that's a really interesting example, I think, about what can be identifiable information. And you wouldn't have expected it, and I wouldn't have expected it, but who knew what was coming around the corner? So the combination of those two fundamental concepts of agency and personal information shows us that this law has to do an enormous amount of work to cover an infinite variety of human interactions right across the economy. And the way that it does that is not by specific prescriptive regulation saying you can do this in this case, but not in that case. Because that kind of law in this scenario would fill libraries. What it does instead is it sets up a set of general principles to guide you and says, through the life cycle of personal information, here's some expectations. And because they're at such a high level of abstraction and generality, they require some judgment of you. And some might say that's bad law, because good law is certain. Bad law is uncertain. This one requires some judgment. But let me just run through this. As a refresher, I'm sorry if this is old news to all of you, but the first principle is don't collect more personal information than you need. My colleagues in Europe call this the data minimization principle. If you don't need it, don't collect it. When you're recruiting volunteers for your church or your charity drive and they have to fill in a form for health and safety purposes or whatever it is, you don't ask what their sexual orientation is. It's no brainer, right? You don't ask have they had any illnesses and what are they. You don't need that information. So just keeping an eye on the minimum, where you can get it directly from the individual concerned. It's a great principle. It puts the individual at the center. This is a law about trying to help people maintain autonomy in a world in which personal information can be moved around without people's knowledge or awareness. It won't work as an absolute principle. None of us can get through a day without breaching that principle. This morning, I texted my secretary to say, my flight's been delayed. Have you got Hamish's number so I can let him know? She texted back saying, it's in your diary, you idiot. But I have collected personal information about Hamish, but not from him, because it's not reasonably practical. I couldn't, it did him no harm. All of these things are permissible because that's how the law has to work. The third principle is really important to charities and NGOs and clubs, because one of the great misconceptions is that this Privacy Act imposes these arbitrary rules about you without knowing anything about your business. It doesn't. It says, you think about this. Why do you need information? Write it down and tell the people you're collecting it from. That's what's required. You can virtually write your own Privacy Act. And if you don't want to call on the services of experts like Parry Field, and even though they're moderately priced, I understand, and excellent service, you might want to jump onto our website, and we've designed a widget. It's called Privomatic, and you can enter a few bits of information about what your organisation does, how you use personal information, and hit send, print at the end, and it will print out a privacy statement that you can then make available to all your donors and volunteers and members, and it tells them, here's what we do with your personal information. So the Privacy Act doesn't say you can't give this information to the church or to the insurance company that you have a sponsorship arrangement with. It simply says, if that's one of the things that you're going to do, you've got to tell people first. So they can say, okay, I'd rather go to Presbyterian social support than Methodist social support with my voluntary services, if that's how you roll. Number 4, don't collect information by means that are unfair or unlawful or unreasonably intrusive. We had a case involving a charity shop, a retail shop that was collecting stuff to resell with the proceeds of which were used to support social services. And one of the volunteers there found that these cameras that are ubiquitous now in retail stores actually had audio recording going as well. And she said, well, I don't feel okay about that. I'm a volunteer. I come here. I have a bit of chit chat with people who come in, with my colleagues. Why on earth would you be recording all of that? Good question, we thought. I think it raises questions under Principle 1. It's an over collection of information. It raised questions under Principle 4, which is this an intrusive means of collecting personal information? And of course, about 3, because nobody, there were no notices saying that. Well, in the end, the charity agreed with us and said, well, true, we don't really need all of that. And so we'll turn off the audio. And we don't really need cameras in the break room where people make their cup of tea. So we'll get rid of those as well. So Hamish and his colleagues received complaints about these principles, and they are required by law to work with the respondent agency to try and resolve it. And so that was the kind of resolution that they achieved in this case. Once you've got the information, you have to keep it secure. Now, most of the reforms that came in last year are really enhancements to this Principle 5 about keeping stuff secure. How secure do you have to keep your information? Well, it depends. How sensitive is it? What could go wrong if it got lost? That will dictate what we think is reasonable. People have a right of access to their personal information. That's a really important one. It's fundamental. How can people exercise their rights if they don't know what you've got on them? We had a case where a person came along to a community meeting hosted by an NGO. And how can I express this in a non-judgmental way? Some people were concerned about the conduct of this person, and there were complaints. And he took offence at the complaints and said, I want all the information you've got about me. Now the agency said, well, we're not going to give you it. And the person came to us, and they're entitled to. So we went to the agency and they said, look, we're really worried. This man seems quite an angry person, and these people made their complaints to us in good faith. And it's a matter of their privacy as well. And often we're having to balance these privacy interests, aren't we? And again, Hamish and his colleagues brokered a solution which led to the individual getting the information that was of interest to him and that he could exercise his next right on, which I'll come to in a moment. Here is what people said about you, but not who said it. And so that, I think, was a useful balance. What that means is that he's able to read it and correct the information if he thinks it's wrong. And he might say, well, no, I wasn't swearing at people in an aggressive way. I actually have Tourette's syndrome, and it may appear this way sometimes, but these outbursts are entirely involuntary, and I would really like to come to the next meeting and explain this and apologise, or something like that, and please correct the record. Okay, so there's often more than 2 sides to a story. So that's correction. Number 8, you've got to take reasonable steps to ensure information is complete, relevant, up-to-date, and not misleading before it's used. 9, don't keep it for longer than you need it. And in the NGO sector, you can write your own policy here. There's some statutory obligations in relation to tax records that you'll need to keep for a specific period, but by and large, it's up to you to make your own policy. You can say, if you want to quit membership here, we'll keep your record for a year or 2 years, so I don't know, for whatever reasons that you might have, but just be conscious of that, make a deliberate decision. You should only use information for the purpose for which it's been collected, which brings us back to 3, right? You thought about why you needed it, you told people, so any secondary purpose is not going to come as a surprise to them. And now we come to the one thing that most people in privacy is all about: don't tell anyone anything. Except it doesn't say that, does it? It says if you're an agency that holds personal information, you must not disclose that to any other agency or person unless you believe on reasonable grounds the disclosure is one of the purposes for which the information was collected, is a directly related purpose, is made with the authority of the individual, is in a form in which the individual cannot be identified, and it's for research and analysis or statistical analysis. So there's a bunch of exceptions. You can disclose information to the police, for example, where it's necessary to avoid a prejudice to the maintenance of the law. So that's 11. We've had a Privacy Act for 27 years, from 93 to 2020. The Law Commission looked at it and said, well, there's been inflation, so we had 12 principles, better have another one. So they slotted in Principle 12, which is about sending personal information overseas, which is really an enhancement of Principle 5, I think. In the old days, as Commissioner, I would say, you're sending your interview records to be transcribed in Mumbai. Okay, well, what steps have you taken to ensure it is secure there? You are liable if it leaks there. The Law Commission, when they reviewed the Privacy Act from 2006 to 2011, said, well, actually, when we're sending personal information overseas, we should have a higher level of protection. So now the law says if you're going to send it to another country, to an agency that's going to do something with it for their own purposes, you've got to do some due diligence, find out what the law is there. If you can't do that, maybe try and send it with a little piece of the New Zealand Privacy Act attached, these model contractual clauses. And we've commissioned another excellent law firm called Chapman Tripp to write model contractual clauses for any businesses or charities that have a relationship with another, with an entity in a different country. I mean, if you're collecting personal information to support a mission, for example, in a developing country, you might have a deal where you send donors' names and addresses to the village so you can have some correspondence or something like that. Now there'll be an obligation to think about the security of that information. And if you can't do those things, check the legal system at the jurisdiction of destination or engage in model contractual clauses. You need the explicit consent of the individuals concerned, having been informed of the risks involved, which may not be very great in that case. So that's the new Privacy Principle 12, and the old Privacy Principle 12 bumps down the list to become 13, and it's about unique identifiers. The new obligation imposed by the Privacy Act 2020 is also really an enhancement on Principle 5. Remember, you're supposed to keep information secure. Well, if you fail at that, and in a way that could cause some serious harm, the obligation is now to notify my office and to notify the individuals concerned. The idea being, if you haven't protected the information, we've got to put control back in the hands of the individuals who could be affected. So they can change their username and password and mother's maiden name. So they can maybe, cut up their credit cards or check their credit reports or replace identity documents, depending on the kind of breach that's occurred. The challenge for agencies that have this obligation is figuring out what could happen. It's a speculative exercise. How do we know if we've reached the threshold that we've lost control of some personal information? How do we know if it could be, if it could cause some serious harm? The Parliament heard a lot of submissions on this as the bill was going through and decided to put some guidance in the Act. So the Act now says, in considering whether you could cause serious harm, take into account how sensitive is the information. Who did it go to? If you tried to send it to Grant at Parry Field and you ended up sending it to Jeff at Duncan Cotterell, and you ring up Jeff and say, hey, I sent it to you, it wasn't meant for you, I'm sorry, I auto-completed on the email. And Jeff says, don't worry, no harm, you can trust me, I've deleted it. Well, Well, yes, you've had a breach, but you've also successfully mitigated that. So it's not a notifiable matter now. So how sensitive, who's it gone to, how widely has it been distributed, how secure was it? So that email that I just mentioned, it had a spreadsheet attached to it. Was there password protection on the spreadsheet? You know, we learn that email is the bane of privacy protection. And people emailing spreadsheets is a really common problem. And the rule of thumb is that in an agency, when you do email a spreadsheet to the wrong person, it will be to the person with the biggest axe to grind against your organization.
Always.
EQC, in a case that will be close to some of your hearts, emailed a spreadsheet that contained what's called a pivot table with the details of 80,000 earthquake claims to Brian Staples, right? The person who set up the anti-EQC lobby group.
Yeah.
So I could tell you other examples, but you get the point. How secure was it? So yeah, have you got that password protection? I've lost track, Hamish. What are the other factors we take into account? Who got it? How sensitive? Mitigation attempts? Security attached? Is there another one? Can't remember. Huh? Yeah, potential for harm, I guess. Yeah. So you've got to tell us, you've got to tell the individuals so that they can take steps to protect themselves. To Kent's question, can that be misused, or are you going to get in trouble in an employment context because you email me and say, well, Hamish has emailed our entire complaints database to our whole newsletter subscriber list, and he's in trouble. Well, okay, you've notified me of this breach and you've told me what the results of your preliminary inquiry are, but that's not evidence in an employment context. You're just meeting your obligations under the Privacy Act. And in any case, I have an obligation to keep that secret unless I need to disclose it to carry into effect the Privacy Act in some way. So I don't think, Kent, that it's really a problem. And I would expect that you would use sort of qualified language anyway. These are always evolving situations. In fact, it may appear that an employee has willfully evaded security measures, but it could be that there was just an accidental failure. And you might need to come back and update as your investigation proceeds and let us know the actual fact. Quite often we see spoofing attacks, right? So somebody is using somebody else's credentials. And so it might appear that person A has been responsible for emailing a whole lot of information out of the organization, but in fact that's been a malicious act by a third-party actor using those credentials. One of the other big segments on the pie of reports, this represents about 75 reports we've had since the 1st of December. 75 is about 1/3 of the total reports we've had. So let me just talk you through these. About 231 people have reported breaches to us. Of those, we reckon about 75 reached the threshold for mandatory reporting. Of those 75, 25% have been email, 21% unauthorized sharing, 17%, a fifth, unauthorized access. Now that means, it could mean a range of things, but quite often it's what we call employee browsing. Somebody with authorized access to an information system who uses it for unauthorized purposes. And this is not something that the charitable sector is immune from. St. John's has a vast database, right? If I have access in order to process donations or the patient movements, then I am expected only to use that for my work purposes, not to look up what records we might have about my daughter's new boyfriend. And we need to have mechanisms to detect that kind of unauthorized access and to audit and so on. Any questions about this slide? Do we have anything coming in on the Zoom?
We have a couple of questions. One of them was around email.
Mm-hmm.
If a client has a large organization and they're sending email to a list of people, can they include everybody's emails in there, or would it need to be hidden? And another one is around resources, what resources you might have around other countries and their privacy laws.
Good, thank you. Look, the first question that you asked is a really common mistake, but it's sometimes of no moment. It doesn't really matter if a charity emails everyone in its database and puts all those emails in the CC field if you're just saying, here are our Christmas opening hours. If you're an addiction service, emailing everyone about your new opening hours and putting all those emails in the CC field carries some other information with it, doesn't it? So I would say the prudent course always is to use the BCC field. Now, I don't understand for the life of me why most email clients don't have that BCC field immediately visible as one of the options. You have to go finding it, and certainly in our Outlook one, and I think in Gmail's the same. So maybe I'll take that up with the software providers and say, yeah, let's make a note. Let's do that. Let's make global change here. I've had an idea.
I would like that.
These are the words that send my staff scurrying to the comments. I've had an idea. Yeah. The second one was: is there any guidance about the state of other countries that we might be exporting personal information to? I mentioned that Principle 12 says you can't send information overseas unless you've taken these steps. So one of the steps was your own due diligence. The other was model contractual clauses. One of the other exceptions there is where it's a sort of whitelisted country, a prescribed country that's been assessed by us and then designated by the minister in regulations. And there have been none designated yet. The minister will write to me and say, John, what do you think about Australia? What do you think about the UK? And I will then do an inquiry and report to the minister, and the minister will make regulations, and that list will build up over time. The minister has said that he proposes to do 1 or 2 a year, but in the meantime, we don't have any. But I should just elaborate, because it's a very complex law, that one. It doesn't apply where you are only sending information to a processor who is not using the information for any of their own purposes. So if your organization uses Slack or, actually we won't talk about Slack for the moment, but if you're just using Microsoft Azure or Amazon AWS, they're just cloud service providers. They don't do anything with your information. They're a stack. The information goes there, is stored there, comes back to you from there. That's deemed not to be a disclosure. So that doesn't require that exception. The other thing that we need to bear in mind is that the New Zealand Privacy Act now has extraterritorial application. What does that mean? It means the law applies to any business doing business in New Zealand, whether or not they have a legal presence here. So if you use MailChimp, for example, to send your newsletters out, that's processing information in the United States. You might say, okay, well, am I disclosing my mailing list to the United States? Do I have to do these things in Principle 12? Well, again, on the one hand, I think MailChimp only processes it on your behalf. So we've got that agency principle exemption. And secondly, MailChimp offers these services in New Zealand, enables organisations to subscribe. So I would say they are carrying on business in New Zealand. They are independently subject then to the New Zealand Privacy Act. So we don't need to have contractual clauses which send bits of the New Zealand Privacy Act with it. They're deemed already to be covered. Kent, you had a...
The question I have is when you look at the terms and conditions for a lot of those organisations, for your core data, they're doing just what you said. They will always have some provisions saying, and we will use this for our own improvement of our services and that sort of thing. How do you see that?
That's a really interesting question, and there's a really dumb. It just sits on the rack and comes in and out. We don't do anything with it. Through to, at one end of the spectrum, through to, we're going to monetize this for our own purposes and sell ads to people at the other. In the middle, there's this kind of phenomenon that you describe. Well, we will use this performance data to improve your experience. but also your neighbours on the rack. I don't know where we're going to land on that. I would say that's more like the not using it for their own purposes. But we may get some jurisprudence on that. I wouldn't worry too much about that.
We're confronting this quite often.
Yeah. Well, one of the other challenges is that the law says you have to make up your own mind about that. If you're in doubt, you have to think about the due diligence. Is there adequate legal regime? Can we use model contractual clauses? Now, you go to one of these companies which has a turnover the size of New Zealand's GDP and say, well, actually St. John's, New Zealand would like these terms and conditions, thank you very much. That's a really tough negotiation. I recognise that.
Yeah, most of our suppliers of our key data are not here because we just don't have that service.
Yeah, that's right.
Just on that, in that kind of mode, there's an element of kind of trust with the person to which you're giving the information. But sometimes there's a very big power imbalance, as you've described, between the person receiving information and yourself. And in New Zealand, just a bit of an aside, there was a change in the Inland Revenue Department, Inland Revenue Act last year that gave the Inland Revenue powers to collect data off you that was not directly pertaining to assessing your tax position,
Yes.
but actually for the purposes of policy making. And across my desk over the last week or two, I've received, you have now been randomly selected for one of our surveys, and we're looking for data out of you for the purposes of, obviously, of connecting the dots, has come as a result of this piece of legislative change in the Income Tax Act.
Yes.
So there's something about perception of, to what extent is the person who's at the bottom end of the power imbalance perception of what's going to happen to that data. Does that make sense?
I do know what you're saying, I think. I just want to take a moment and check something. Could somebody on Zoom just indicate to our controllers whether the questions are coming through? You're hearing those? Because otherwise I can repeat them. Someone give a thumbs up. Sorry, what was your name?
Michael.
Someone give a thumbs up to Michael. Yep, we're good. Okay, thank you. So look, I do understand. Look, there's a really easy legal answer to your question, which is that the Privacy Act, for all its importance and special place in our hearts, lies at the bottom of a heap of other legislation.
Yeah.
And the tax acts override it. So when the IRD writes to you and says under Section 17 or whatever, or the Ministry of Social Development comes under Section 11 of the Social Security Act and says, you need to give us this data, it's not a defence to say, well, actually, I can't under the Privacy Act. Those other legislations override the Privacy Act. I mean, I think you're raising more of a policy issue, and I have some sympathy for it.
Yeah.
There's ask any lawyer about the anti-money laundering, countering foreign terrorism regulations, right? And the amount of information that we're required to collect about identity and business transactions and submit it to an official report. What privacy? People, sometimes quite legitimately say. So there are these carve-outs, but even those, we do patrol. We look at them and say, well, we know you've got the power to do it in a legal sense. We know it's not a breach of the Privacy Act, but is it reasonable? And I did an inquiry a couple of years ago into the Ministry of Social Development's undertaking of fraud investigations. And what they were doing, they have an administrative power which allows any low-level official at the Ministry of Social Development to write a letter without any judicial oversight, no warrant or anything, to write a letter to someone demanding information in the course of a fraud inquiry. And a fraud inquiry can be somebody rings up trying to dob in their former partner, and we found that this power was being used in extraordinary ways to get years worth of banking records. We were finding women, because it was almost always women, being called into meetings to discuss their benefit eligibility and being shown intimate photographs from their own phone that they had taken from the telecommunications provider under one of these powers. Now that is a kind of surveillance of the sort we would object to, I think, if we saw our national security agencies doing it on a willy-nilly basis. So I understand and sympathise with the point. We do kind of patrol that and try and make sure that these powers are exercised in a proportionate way, and that when there's a legitimate reason for collecting the sort of information that you describe, that it is ring-fenced and used only for that purpose and treated respectfully, and that these other privacy values are respected. I'm not sure if you're that interested in how we do what we do, but I've got a couple of slides. We have new powers under the Privacy Act. For 27 years, the Privacy Commissioner, may surprise you to know, had actually no power to punish breaches of the Act or to enforce the law even. All we did was people complained and we'd try and get the parties together, and at the end we might say, yeah, it's a breach of privacy and you suffer terrible harm. Here's a letter telling you that. If you wanted actual remedies, you then had to go to this body called the Human Rights Review Tribunal, which remains, to get the compensation, the civil remedy that you're entitled to. Now, in addition to that compensatory regime, the Commissioner has the power to issue compliance notices, to go around to agencies and say, hey, you're doing this thing, it's not consistent with the Privacy Act, stop doing it. Or you're not doing something that you should be doing. You're collecting this information, you're not telling people why. Here's a compliance notice. Put a notice under that video camera, please. So we've had to think about, with these new powers, how we exercise them, how we allocate our resources. And we've been thinking about moving into a more punitive regulatory role and how we do that responsibly. So we are asking Hamish and his colleagues to think. We're doing it at an organisation-wide level, but also at an individual case level. What happened? Why should we look into this thing? How big a thing is it? Is it a really big thing for you and you're therefore entitled to have an investigation? Well, you can have one. Or is it a small thing for you, but maybe has wide implications across the economy? If there's lots of people in the same position, maybe it is something that we need to deploy some resource into. If it doesn't matter much to you and it's not a big thing for the economy, then we can't justify deploying our scarce resources on it, okay? That's the kind of thinking that we're going to be doing and deciding whether or not to pursue investigations and the like. It's a sort of standard regulatory pyramid. We try and put most of our emphasis at the bottom here on awareness and education, getting people to comply. We know you have all come along here because you want to understand the rules and apply them properly. So we're going to try and meet you and provide you with what you need to make it easy for you. We're not going to start issuing you with compliance notices because you've made some misstep, because you waited an extra day before notifying us of the breach because you weren't quite sure what happened, or you wanted to check out this issue about employment versus, it's a legitimate question. So you're doing the right thing. We're encouraging compliance. And again, here's our decision factor on how on where we're going to land in the compliance, in the regulatory pyramid. What's the conduct? Willful, negligent, repetitive, accidental or one-off? What's the impact? Is it widespread and significant? A really good example of how we use this is, Hamish looks after a couple of assistant investigators who run our inquiries desk. And often on a Monday morning, someone will call up and say, hey, I went to look at a flat on the weekend and the landlord said, even to have a look at it, I had to provide all my social media identities, 3 landlords' references, the names of all my family members, and 6 months worth of banking records. And it just felt awful. I felt I had no choice, and is there something you can do about that? And for many years, all we could say was, well, yeah, we understand that, but let me tell you, if you want to make a complaint to us, you've got to allege an interference with privacy, and that's a term defined in the law, and it says it's a breach of one of those information privacy principles, plus some actual damage or loss, or significant humiliation, significant injury to feelings, or loss of dignity. So the call is saying, yeah, we hear you, and you're absolutely right. It sounds like it's a breach of Principle 1, Principle 4, but actually feeling a bit stink isn't going to get to that threshold. So you can't make a complaint. You're not going to get to the tribunal. We're not going to investigate. It's not that we don't care. It's just that there's not really anything we can do. Our threshold for issuing compliance notices is lower. We don't, it's non-compliance. It doesn't have to have that threshold. And now we're able to look across the economy when we get that call and say, okay, so you can't get the remedy for that person. But this is an experience repeated hundreds of times up and down the country. So maybe it's something that we should have a look at. Even though the individual case, the aggregate, is quite extensive and it's affecting a lot of people in a reasonable way. And in fact, this is what we do. We've set as one of our priorities for this year, getting into the residential tenancy marketplace and setting some really clear rules for people and then going out to enforce them. COVID was...
Sorry, it might be a good point to address employment and privacy matters as well. Just a question around that and how we, if there's an alternative.
Oh, yeah, true. Yeah, true. We are trying to match people up with their appropriate remedy, and we quite often see employment disputes have a privacy dimension to them. And in fact, almost every employment dispute begins with you've done something wrong with me, I'm going to bring a grievance, give me all the information you've got. So exercising that principle sits right. Well, if there's a dispute in train, we will very often ask the parties to use the specialist forum that is the principal issue. So if it's an employment dispute, really you should be taking it up with the Employment Relations Authority. And we'll be more directing agents, complainants and agencies to those. I'm going to pause now. Actually, I'm not going to tell you what we've been doing with COVID unless you're interested in it. You can ask a question. I thought it would be better. Oh, look, sorry, I got ahead of myself. Somebody asked about awareness, how we operationalize this.
Yeah, what are kind of your top threes that everyone should know?
Well, what I would say is, in your sector, I would say, go to our website, privacy.org.nz, find our online training, Health ABC. ABC is just a really high level, keep stuff secure. It's the real administrative, operational level. The people who cause risk in your organisation are very seldom the ones who are reporting at the Risk and Assurance Committee. They're the ones who you ask to print out that document and put it in the envelope and send it to the person. And they go to the printer and they take out 3 documents, put them in the same envelope and send them out to that person. So, privacy is sometimes just about thinking at a really easy level. Let's put a notice by the printer saying, check you're sending only, check the match between the envelope and the letter, for example. That's that sort of basic level. So I don't know if I've got a top 3, but I would say these online courses, certainly the ABCs, everyone in your organisation will be able to get something from them, and it'll just raise their awareness. What we originally did, I said when we started rolling out these online courses, is I said to our developers, I want a really basic thing for everyone so that they understand the Privacy Act. And so we issued Privacy 101. And people came back and said, yeah, it's really good. Boy, it's a deep dive. So, for us who do this stuff every day, what was the absolute skimmed across the surface basic, for others was kind of a PhD in privacy law. So we went back and said, okay, we need to raise it up. What are the basic principles? ABC. And the instruction really was, don't mention the law. People don't want to know the section, they don't want to know the terms, they just need to know, careful who's photocopying you, putting in that envelope, that sort of thing. Any questions coming in on the Zoom?
We have a few. I think you might have touched on it a little bit. So one of them was resources for vulnerable people or people with learning difficulties or low literacy, what you might have, but I think that those resources might be useful there. The other one was how to assist with volunteers and helping them understand an organization's private policy. I think those resources might also...
Yeah, I think they would, Michael. They, you could have, as part of your induction for volunteers, a suggestion or recommendation or even requirement that they complete the ABC at least. The first one was vulnerable people. This requirement here, remember the privacy statement, the law says the agency that's collecting personal information must take reasonable steps to ensure that people are aware of. Now, when I come and have a look and say, well, did you take reasonable steps? I'm going to say, well, what's reasonable for the community that you're serving? If you're a charity providing services with visually impaired people, and your answer to the privacy principle is to put posters up around the walls and 10-point font on the back of your brochures, I might say you haven't taken reasonable steps. If you're running a service for intellectual disability, I'm going to say, well, how are you communicating these concepts to your client base who are entitled to have information in a way that they can absorb and understand it? So these are going to be challenges, I think, for you based on the audience that you're interacting with.
Just another question in terms of data processes. Does the Act not also extend to service providers? You are paying to provide services on your behalf, provided they are directly bound by your contract under the Privacy Act, or equivalently higher standards legislation, such as the GDPR.
So the GDPR is the General Data Protection Regulation, which all European countries are obliged to comply with. And many companies that are operating in different jurisdictions set their privacy policy at a level that complies with the GDPR, so they don't have to mix and match. And I think probably if the agency that you're dealing with is warranting to you that they are GDPR compliant, I actually think it's going to be enough for you to put your hand on your heart and say, I believed that there was a comparable level of privacy protection in the place that I sent this information.
And from the opposite, just something from the opposite point of view that I used to find frustrating was people, you'd ask for information and you'd be told, I can't give you that under the Privacy Act. How do you deal with that? When,
in what context though? So you're talking about when, I mean, there's
a legal context or in an employment context where you're trying to find out, no, I can't tell you that, and you know that there's information that they've got about your client, but they're saying, sorry, we can't tell you that.
Yes.
Or you used to ring the airline and say, so on an aeroplane, no, we can't tell you that because it's the Privacy Act. Yeah, under the Privacy Act. So it seemed to be...
Actually, that airline one's an interesting example because I remember the very first privacy commissioner went to the airport in mid-1993 and saw one of these signs saying, sorry, we can't give out passenger details because of the Privacy Act. And he rang the airline, the chief executive, and said, well, what were you doing last month? And they said, oh, we never used to give out passenger details. It's our policy. And they said, well, can you change your signs and not blame it on my Privacy Act, please? So they changed their policies to say, we will not give out passenger details. It's confidential. That's our policy. This is consistent with the Privacy Act. As a lawyer, it can be frustrating, but in most circumstances, lawyers have a written authority that should satisfy people. But when I was in practice, I was constantly educating agencies to say, listen, the Privacy Act says you can't disclose information unless you believe on reasonable grounds the individual is authorised. Now, I'm a lawyer. If I tell you I'm acting for this client and I am not, then you can make a complaint to the Law Society and that's my career over. So I'm acting for them. You are authorised to give me that information. Please don't make both our lives more complicated than they need to be.
I've been involved in writing the privacy policy for a very small NGO that I'm a committee on. And I'm just wondering how important is it that legal eyes look at the policy that I have written. So I've used your very helpful website and I've probably gone to 60 other NGOs and looked at their privacy policy.
60?
At least.
Goodness.
So I'm on there looking. I'm also looking at child protection policies because I'm trying to write the child protection policy. and I want to get it right,
Hmm.
but do I need legal eyes to look and check that we're
You know,
covered?
I don't think so.
You could teach them.
I mean, when you look at Principle 3, it's written in reasonably plain language. It says what you've got to tell people. You know, if you go to a lawyer and say, I need a privacy policy, if they're good, they'll say, okay, well, tell me what your organisation is. Tell me what you do. How do you use the information? So they're just going to take stuff that you already know about your own organisation and give you a bill for $500.
That's what I'm worried about. Not the money to be doing it.
So no, I think you'll be okay. And especially, I mean, if you're using our Prebomatic,
Yes.
you know, we're very unlikely to come and beat you up for using our own tool to produce policy for your own modest and philanthropic organisation. Yes.
Hi, I'm an activist as well as the privacy officer, and quite often there's a bit of tension from our stakeholders' point of view, because they might request information that's deleted or removed, whereas from a private records management point of view, under the schedule, I'd say these need to be retained. And just wanted to check that I'm doing the right thing, because I just note that their request and append to the information, but I don't actually delete their information, and I explain to them why we don't delete it, because our archive requirements kind of override it. Is that okay, or am I going to get into trouble?
Well, again, it's your policy. We don't have a right to erasure as such in New Zealand in the way that they do in the GDPR, or a right to deletion, or a right to be forgotten, as it's sometimes called. You know, if you're in Europe and you have a dispute with your power company and you say, okay, I'm going to switch power companies and I want you to erase any record you have of me, they have to do that unless there's some compelling business reason not to. Here, we have a right to correction, which, the definition of correction in the Act says includes deletion, but that's correction by way of deletion. It sounds to me as if the people coming to you are not saying, that's wrong, delete it. They're saying, I don't want you to hold it, delete it. Now, they can't, Principle 9, which is the non-retention principle, is not a right that a consumer can assert. I can't say, I demand that you not retain my information. It says you shouldn't keep it for longer than you need it. What you're telling me is, whatever your organisation is, you have a legitimate reason to retain it. Now, you're sitting next to Elizabeth, so you might be the Catholic Church. I'm just trying to think what possible reason you would have for long-term retention of information. Yes, for eternity. Just keep it until Judgment Day, perhaps. But yeah, no, look, I'm sorry, I shouldn't attempt humour. No, it sounds to me as if you're doing the right thing. I have seen cases where people are so affected by the knowledge that this really hurtful information remains on a file, and it may be disputed as well, that they said, you've got to get rid of it. And the person says, look, I'd love to, but I'm subject to the health retention regulations or the Public Records Act, and I can't. And I've seen deals brokered where the 10 pages goes into a sealed envelope, noted this must not be opened by anyone without the authority of the so-and-so, and notifying the person in advance. I saw one case where somebody was receiving a particular benefit. I think we need to go quite soon, don't we? But I'll just tell this little anecdote. This woman was misdiagnosed with a mental illness in the 1970s, completely misdiagnosed. She had actually put out her back or something. She was taken from this Defence Force service where the injury had occurred straight to a psychiatric hospital where she was diagnosed on the steps and given an injection. She had an adverse reaction to the injection, which had caused her ongoing health problems. There were about 7 pages of notes about her supposed psychiatric condition, which affected her for 20 years. She didn't know they were there. But every time she went for a health service, she was treated as if she had a psychiatric condition. When she finally exercised her right under Principle 6 to get them, she was horrified, and she said they've got to be removed and deleted. That was never true. I've got all this psychiatric evidence saying that was a misdiagnosis, I never had that problem. But the problem is, the benefit she was now receiving was based on the adverse effects of the antipsychotic medication. So without retaining the history, that made no sense. So as hurtful as it was for her to know that incorrect information was on file, there remained a legitimate reason for it, and so some sort of halfway had to be reached to resolve it. Are there any other compelling questions? Anything on the Zoom, Michael?
No.
No? Good? Nothing else in the room?
Just one final one.
Right.
The temperature in society generally seems to be going up, as evidenced by road rage, supermarket, teller confrontation, so on. Are you getting more frivolous complaints?
What do you think, Hamish? Frivolous?
Maybe higher expectations of compensation for something that might be something that could be worked out between parties, I would say. Yeah.
I think we do get angry complaints, don't we? People who are just, people maybe feeling disempowered. You know, sometimes people come to us and they just want to punish that other organisation. But Hamish and his team have an obligation to try and settle. So when you're really angry at someone, sometimes the last thing you want to do is to be told, well, you actually have to sit in a room and have a conversation. That can be very healing. And someone from our team recently mediated a dispute where the party, the aggrieved party, asked for it to be held in accordance with tikanga Māori. And it was a very Pākehā organisation. But that request was accepted by the other party. They all came to Wellington. They had a special stone which denoted a right to speak. They opened with prayers, and I think there was some singing, and they didn't resolve the complaint on that day, but everyone came out of it feeling like they'd been heard and that they'd been respected. And I think a week later, they did actually manage to resolve it. So, you know, there is some, I think we have a role sometimes in maybe bringing that temperature down a little bit. Thank you everyone for coming out and for dedicating this little bit of time to privacy in this 1 week of the year that's devoted to it. I know there's many other things that you have to do to keep your organisations running. Privacy is only one of them, so really appreciate giving us this time and attention. Thank you.
Thank you.
Thanks for being here.